In this section, we will give you an overview of the party wall process and how it fits into your building project. Once planning's been submitted under permitted development, or you've got a first draft of the project plan, you should start off the party wall process. Once the party wall process is completed, then the build can begin. Of course, it's possible to begin the build where the works are not notifiable, or do the non-notifiable element of the works. It's usually better to make sure that the party wall process is either running or completed. Once the build is completed, occasionally there will be damage to the neighbouring property, and this is where you will go into the post-works party wall process, repeating it's only if damage occurs. Just to repeat, the post-party wall process only occurs if there is damage to your neighbouring property. So let's have a look at the party wall process. First stage is to analyse and create notices. So we look at the proposed building works, carry out analysis of the notifiable works and how it's likely to affect your neighbours. We then create the notices which are served to the relevant adjoining owners. The main element of the party wall process depends on the response received from your adjoining owners. They basically have four options. They can consent and request a schedule of condition. Now, the schedule of condition is actually here to protect the people carrying out the building works, offering protection from false and malicious damage. Very similar to renting a car, where the car renter takes photographs of the car before it goes out to you, so that any existing damage can be logged. The next option the adjoining owner has is to use an agreed surveyor, i.e. use the same surveyor as you. Here, both building owner and adjoining owner are using the same surveyor. The third option for the adjoining owner is to appoint their own surveyor, in which case there are two surveyors. The building owner has a surveyor and the adjoining owner have their own surveyor. The fourth option is not really an option, but it does occur on a regular basis, whereby the adjoining owner does nothing. We will look at each of these in turn. Where the adjoining owner has consented with a schedule of conditions, the process is as follows. We make an appointment to view and carry out a schedule of condition on the adjoining owner's property. We carry out this survey. It's largely photographic. The photographs and the survey is held on file in case there's future claims and to avoid malicious and false claims. We also produce a written report known as the SOC report. This report is then sent both to adjoining owners and building owners. If the adjoining owner selects the agreed surveyor option, whereby the same surveyor acts for both building and adjoining owners, this is permitted under the Act on most occasions, apart from where the works are basement works. The process is as follows. We will make an appointment with the adjoining owner to inspect their property. We will carry out a survey of their property to notify its pre-existing condition. This is largely a photographic survey. The next step is to produce a report for the photographic survey, known as a schedule of condition report. We also produce a legal document called a party wall award, and the schedule of condition report forms a part of that award. The award is a legal document which sets out rights and responsibilities of each party. The last step is to serve the award to both the adjoining owner and the building owner. The third option for adjoining owners is to appoint their own surveyor. They are allowed to do so under the Act. In most cases, the building owner will be responsible for that surveyor's reasonable fees. So, the building owner appoints their own surveyor, the adjoining owner have their own surveyor. The first task for the two surveyors is to appoint a third surveyor who will only get involved should the two surveyors or either of the owners call upon him. The adjoining owner surveyor arranges timings for a schedule of condition survey. The building owner surveyor carries out that survey and produces a draft report for that schedule of condition. The building owner surveyor also produces a draft party wall award, which is a legal document setting out rights and responsibilities. Both these documents are then sent to the adjoining owner surveyor to review and comment upon. The adjoining owner surveyor will comment upon the documents, the party wall award and the schedule of condition report. The building owner surveyor responds to those comments, and this can go back and forth for some time. It's not uncommon for the adjoining owner surveyor to request amendments to the drawings, method statements and various other documentation, which the building owner surveyor requests and passes on. The party wall award and the schedule of condition is agreed by both the adjoining owner surveyor and the building owner surveyor. It's then signed by both the building owner surveyor and the adjoining owner surveyor. The building owner surveyor serves the documents to the building owner, and the adjoining owner surveyor serves the documents to the adjoining owner. Where the adjoining owner has selected the fourth option, i.e. done nothing, not answered your letters, it is deemed to be a dispute after 14 plus days for postage, so we usually allow 16 days. The next step is to send a reminder letter giving them 10 plus 2 days for postage. If there's still no reply, the building owner must, and I repeat, must appoint a surveyor on their behalf to act for them. Now, prior to appointment of a surveyor, the adjoining owner may reply, and again has the three options of consenting with the schedule of condition, using an agreed surveyor, or appointing their own surveyor. The adjoining owner is not allowed to frustrate the process by non-reply to the party wall notice.